Members of the Tribunal, in my opening statement, I said that this case, this complaint, was brought to you by the Filipino people, and I said more in particular, by the peasants, the workers, the urban and rural poor, the fisher folk, the women, the youth and students, indigenous people, national minorities, migrants, human rights defenders, journalists, legal professionals. And that might have been, at that time, an abstract, a rather abstract form. But I think you've met all these people. You've met them through the witness statements, both here on the witness stand and the witness statements by video. You've met these urban poor, peasants, organizers, young youth, young people, and you've heard how they have been concretely victim of the violations that were denounced in the opening statement and in the indictment. The complainants began by first laying down the fact that the Philippines is in the midst of a decades-long armed conflict between the government of the Republic of the Philippines, backed by the government of the United States, and on the other hand, revolutionary forces represented by its political authority, the National Democratic Front of the Philippines. This armed conflict is not just a gunfight. It's a war of national liberation that is carried out in the exercise of the Filipinos' people's inherent right of self-determination. This right, along with the concomitant right to engage in armed struggle in the exercise, therefore, is recognized under international law. By all accounts, the GRP and DFP conflict satisfies the intensity and organizational thresholds for the existence of an armed conflict as required and as defined by international law, triggering ipso facto the application of international humanitarian law. The response of the GRP to this war of national liberation, with the full support of the US government, has been the violent repression of the Filipino people throughout counterinsurgency and counter-terrorism campaigns, the restriction of civic space, and the curtailment of democratic rights, and of course, widespread violations of human rights and international humanitarian law. Despite the own commitments of the government of the Republic of the Philippines, reflected in the Comprehensive Agreement for the Respect of Human Rights and International Human Rights Law, the CARIL, to respect international humanitarian law and human rights in its war against the NDFP, and despite the obligations arising from treaty and customary international law, the counterinsurgency campaign waged by the GRP is marked by widespread and systematic human rights and IHL violations, ranging from the murder and torture of persons hors de combat, of which we saw several, on which we heard several witness statements, of hors de combat and unarmed NDFP consultants, to the indiscriminate use of force and the deliberate targeting of civilians, to massacre, forced displacement of entire communities, abductions, and enforced disappearances. And such crimes, such atrocities amount, of course, to crimes under international law and in the context of an armed conflict to war crimes. To give context, the complainants introduced the testimony of resource persons who are experts on international humanitarian law, on the right to self-determination and national liberation movements, as well as on the counterinsurgency policies and its effects on the people. And thereafter, the complainants presented testimonies on 11 emblematic cases, of which 5 occurred under the Duterte administration and 6 under defendant Marcus Jr.'s term to illustrate the violence and repression that the defendants have committed in the course of the two administrations. All the victims of the cases that were presented to you, all the victims of this criminal conduct enjoyed the status of protected persons under IHL, under international humanitarian law. And you've seen the pattern unfold. Red tagging, harassment, including judicial harassment, violent acts, forced surrender, and then ultimately killing, massacring these protected persons. Apart from these emblematic cases, the complainants submitted other significant incidents that illustrate the breadth, the magnitude, and the intensity of the violations of international humanitarian law committed by the defendants to further substantiate the allegations, the executive summaries of which have been handed over to the clerk of the court. Overall, the evidence presented by the complainants, both testimonial and documentary, exemplify the acts on the part of the government of the Republic of the Philippines with the full support of the US government that constitute violations of international humanitarian law or war crimes for which they must be held liable. As also mentioned in the introductory statement, this is not the first time that the complainants charge the defendants for violation of international human rights law and a multitude of human rights instruments. In separate sessions of the People's Tribunal that were held in March 21-25, 2007 in The Hague, in the Netherlands, on July 16-18, 2015 in Washington, D.C., and on September 18 and 19, 2018 in Brussels, in Belgium, the Filipino people charged the government of the Philippines and the US government for gross and systematic violations of civil, political, economic, and cultural rights, for plunder of the national patrimony and the environment, for the misrepresentation of the exercise of the people's right to self-determination and liberation as so-called terrorism, and the baseless designation of individuals, organizations, and other entities as terrorists by the US and other governments. In all these sessions, the defendants were adjudged guilty of the charges, which the tribunal concluded involved conduct amounting to war crimes and crimes against humanity. In the years that followed, the policies of the GRP and US government, which created and maintained the conditions leading to widespread human rights violations, remain firmly in place and have even more intensified. The GRP's foreign and domestic policies remain subservient to and are dictated by the United States. In national security terms, this subservience is reflected in US involvement in the campaign against the NDFP through policy setting, training in counterinsurgency warfare, financing and supplying of weapons and war material used against civilians and revolutionaries alike. This conduct of the defendants are serious violations of international humanitarian law and gross violations of international human rights law rules and standards applicable in situations of armed conflict forming part of conventional or customary international law. And they are, of course, also violations of jus cogens norms as well as generally accepted principles of law. It is high time that such violent and repressive policies of the GRP, implemented with the prodding of the US government, be put to a halt. To hold them legally responsible for the violations against the Filipino people, and to break the culture of impunity under which the defendants confidently take cover to the detriment and prejudice of the Filipino people. It is only when we are able to bring the defendants under the strong arm of the law and put them to account for their actions that the Filipino people will see a just and lasting peace. There can be no peace without justice. Thank you.